Hello everyone, welcome back to my channel. Don't forget to like, comment, and subscribe the channel. Okay, today I will tell you about maritime law and contract. Well, the roots of maritime law can be traced back to the Papal Bull of 1493, which divided the world oceans between Spain and Portugal, solidifying Spain's claim to Columbus' New World discovery. In 1608, Dutch jurist Hugo Grotius and English academic John Salter argued for freedom of the seas. Their arguments were ultimately rejected, but these two legal figures paved the way for maritime law in our modern age. International Maritime Convention. The purpose of the International Maritime Organization, or IMO, is to promote the adoption of the highest standard for the ship and other seagoing vessels. This convention also aimed to ensure the efficient navigation of seagoing vessels and to prevent marine pollution from ships. The IMO oversees four conventions. Convention on Oil Pollution, a common problem for ship owners, address the issue of marine pollution. This convention requires ship owners to use compliant, full, and adopt advanced emission control technology in order to reduce air pollution. They deliver substantial public health and air quality benefits. But that is the purpose of this convention. Let's explore some of the most important conventions for shipping. Well, in general, the CMI database contains a vast number of case studies, case law analysis, and commentary on international maritime law. This database is accessible to judges, lawyers, and academics. It also provides a list of judicial decisions concerning interpretation of maritime conventions. By referencing this database, judges, lawyers, and academics can quickly find case law pertaining to their interests. This makes the CMI database particularly valuable. The IMO has also amended the Convention on the Suppression of Unlawful Acts Against Maritime Safety. It aims to ensure appropriate action is taken against any person who commits a crime against ships or fixed platform engaged in offshore oil exploration. As a result, more than 5,000 people have died since the convention took effect in 1992. Those responsible for these crimes face death penalties, and IMO has adopted a number of other international maritime conventions that aim to protect the environment. IMO is governed by U.S. constitutional law. Article 11, Part 2, grants 2/3 of the senators the power to make a treaty. Convention also grants the flag state the power to enforce the standard of the agreement, but in reality, the U.S. Constitution is the one that governs the interpretation of international maritime conventions. It also provides a legal basis for judicial enforcement. The IMO will continue to be relevant in this regard. Seamen. Many individuals work in the maritime industry along the Gulf of Mexico, but not all of them qualify as a seaman. Under federal and state law, a seaman counseling service, which has her offices in Galveston, Beaumont, Port Arthur, Rockport, Corpus Christi, and Victoria, Texas, can help those in need of maritime employment advice. Seaman counseling service attorneys are experienced in assisting employees in maritime employment issues. In most cases, a seaman may seek compensation for pain and suffering, disfigurements, mental anguish, and lost wages. In addition to the pain and suffering a seaman may experience, he or she can also seek compensation for economic losses, such as future earnings capacity and lost fringe benefits. However, if the ship owner was negligent in some way, the seaman may be able to sue for future medical costs. The Jones Act and other maritime laws protect the right of seamen injured in the course of their employment. Employers are liable for the action of their employees, including crew members. A seaman may not file a lawsuit against their employer if the ship is seaworthy, but it can still be liable for injuries sustained while on duty. It is important to find an attorney familiar with maritime law and the Jones Act to protect your interests. The Jones Act is a federal statute that provides compensation for injuries suffered by seafarers. The Jones Act addresses maritime commerce and protects seamen from being exploited by employers. Employers are also required to maintain their vessels and safety equipment and meet standards for crew qualifications. It is important to note that while the Jones Act allows injured seamen to recover workers' compensation benefits, they must be able to prove that their employer's actions were negligent and that they suffered injury due to the negligence of their employers. Maritime contract. Maritime law applies to contract between parties on navigable waters. It supplements state law, and federal court honor the party's choice of law. Most states apply the law of the state with the greatest interest in contract. In many cases, however, maritime law doesn't apply. This situation can be resolved in favor of the seller. Maritime contracts often have complex legal and practical implications. Listed below are some examples of maritime contract. The first before 2004, courts were permitted to hear mixed contract dispute based on the definition of maritime contract. Such contract contain both maritime and non-maritime elements. The non-maritime portion of the contract though could be separated. That was a reasonable approach, but it still not provided certainty or uniformity. That is why it is important to consider the jurisdictional requirements of maritime contract. If you are planning on filing a lawsuit for breach of contract, you should be aware of the maritime law jurisdiction requirements. Whether the contract is a vessel or a land-based construction site, it is important to understand the maritime indemnity scheme. Most maritime contracts include provision for knock-for-knock indemnities with the vessel owner. As a general rule, maritime indemnity provisions are not enforceable in the absence of negligence. If a seaman is injured on a vessel, their employer may be held liable under maritime law for resulting injuries. Maritime law is a collection of international conventions and laws that regulate private maritime activities. These conventions govern maritime safety and environmental issues. Individual nations sign and enforce these international agreements. Maritime contracts are one way to protect both parties. The rules and regulations governing the sea are constantly evolving and improving. And it is crucial that you learn more about maritime law to protect your interests. You will be glad you did. And then, Statute of Limitations. Maritime statutes of limitation apply only claims made against seagoing vessels. There are exemptions for pleasure yachts, tank vessels, fishing tender, canal boats, car float, and other non-descript vessels. This section of maritime law also applies to claims for personal injury and death. Whether or not your claim is time-barred depends on the circumstances of your case. But in general, filing a claim as soon as possible is the best way to make sure your claim is not outside the statute. As with any other area of law, maritime law has a number of specific aspects. Knowing the status of limitation is essential if you are planning to bring lawsuit. Regardless of where you are based, maritime law generally applies to the jurisdiction where you work. Okay, that's all for today. Thanks for watching. Don't forget to like, comment, and subscribe this channel. See you in the next video, and bye-bye.